For my side or like your side?
Both.
Okay.
Both.
So it really kind of depends. It very much depends on what somebody's looking for. But honestly, it's not that bad, especially for, I'm trying to make it as easy as possible too. So the way my system would work is I would meet with somebody. It's about an hour and a half, 2 hour meeting, depending on if they're willing to do homework and exams, which can speed up the meeting, of course. But we go over just literally everything, all of your finances, your family life, kind of what your goals are, what your concerns are, what you want to happen, and when you pass, and if you're incapacitated, make sure the right people are in place to take care of your finances and to make your healthcare decisions if you're ever unable to. And then also, if you have minor children, to go over exactly what you would want to have, do you want to care for them? If there's somebody you don't want to care for, to make sure we plan for that too, so that the judge is aware of these people we do not want to get the children, and this is why. And then just making sure all of that's set up properly. So we do that, and then I go back and I go through everything, send information to you to confirm, make sure everything looks right. And then about a month after our first meeting, we get together again and sign everything, and then kind of go from there. And some of what we're going to talk about today is, even if you have a will, I would suggest to you that's not really enough, because under Oklahoma law, if you have a will, you still have to file that in court. And you have to go through the probate process. So your family would have to go to court and have the judge sign off on everything, have it all approved, even though you've got a will, because that's the way Oklahoma law works. And so you can get a trust, you can avoid all of that. You never have to go to court, and everything's just done with transfer of title. Much simpler.
So it's best to have a trust.
It's very much so.
Wow.
And we'll talk in depth about what probate really looks like, how expensive it is and time consuming, and a lot of that today, so that you can kind of see the differences. And some people, they may decide they still just want to live. And that's up to them.
Wow, okay. Well, I have grown children, but I've written out everything that I've instructed for them to do,
Yes.
but it's not notarized, or it's not filed, it's just written on a piece of, notebook paper, what I want, but I didn't understand that you really need to do a trust.
That is by far the easiest way for you.
Okay.
So when something happens to you, if you have a trust, that makes their life so much easier. They don't have to hire an attorney and go and file it in court. They don't have to go before the judge and have that long drawn process where they're just doing all of that. Anytime you're in court, it's a nightmare.
Right.
So if we can avoid that, it's definitely the best option.
Okay.
And then we would just look at all of your assets and just see what the best setup is for you and for your family, and go from there.
Okay.
And then also, a couple of things to always keep in mind is you definitely want a financial power of attorney, so that if you're ever incapacitated, someone immediately has the authority to go to your bank accounts, to pay your bills, just to make sure your life financially doesn't fall apart while you're in the hospital or while you're unable to make those decisions. And the same thing with an advanced healthcare directive, to make sure your wishes are down and someone has the authority to make those decisions for you with the hospital or with your doctors, so that there's no question. And again, if you don't have it written down, depending on your family situation, someone may have to go to court to get permission to make those financial and medical decisions for you. And obviously there's a delay there and there's a cost there. And all of that can be avoided just by doing things.
Okay. Thank you.
Of course.
Like, my daughter's a financial advisor.
Excellent.
And she kind of hit on it a little bit, but it's like, I'm listening, but I'm not listening. She said, Mom, maybe you need to do a will. And I think she did say something about a trust. Well, I know my parents had a trust. My dad passed away 7 years ago. So my mom, my mom, whatever, the trust. So there was no court, to be or nothing like that. But I just thought, because I have my daughters on my accounts, to whereas I thought, okay, if something happens to me, they're okay. They won't lock my account.
So they won't. And here's the only risk that you're running. If your daughters would ever get sued, they can come and seize your accounts to pay your daughter's judgments.
Wow.
Because now your daughters own those accounts. Like if they're on there if their name is on them,
Mm-hmm.
that opens up liability for you if something were to happen, then even just a car accident, something simple.
Really?
Yeah, it's an easy way to do it, but it's a big risk.
Wow. Okay.
So there are others, like you can do a pay on death beneficiary where when you die, that money automatically goes to them. But they don't have the authority if you're incapacitated, if you're unable, they can't go in there and do anything with it. So those are the things that we would kind of work through just to make sure you're always protected. We don't want to see anything like that happen. And people do that with their homes too. They'll put their kids' name on their homes and think, I'm good.
Right.
But the same kind of thing, if your daughter gets sued, if they have a judgment, your home is an asset to your daughter
Okay.
at that point because she's an
Okay. Wow.
Yeah.
Ooh, okay.
yeah.
All right. Because I did a quick claim deed with all three of my children on the
Okay.
home because I was previously married to their dad. So if anything happened to me, I'm thinking they're safe.
Yeah.
They're not safe.
You're not safe.
Okay. Excuse me, I got homework.
Yeah. And then the other thing is, are they on your title now as owners of your home? Like you did a quick claim deed, did you list them basically as owners?
That I gotta double check on.
I would check on that too, because then the other issue is if they're listed as on the title, like if they are actually listed on your title as an owner of the property, you can't sell it without their permission now either.
Okay.
And of course, most of the time that's not a problem,
Mhm.
but every now and then, when it comes to
Yeah.
money,
Yes.
you just
Yes.
never know.
Yes.
And you don't want to take those risks unless you just have to.
I got homework. I seriously got homework.
Well, and that's what I'm here for.
Okay.
So if you ever need anything, please
Yes.
let me know.
Okay.
Happy to sit down. We can go over much more detail,
Okay.
and then you can see
Okay.
if there's anything you want to change or what we can do to help.
Okay. Oh, yes. Ooh, okay. It's too early for all of this. But hey, it's educational. It's things that we need to know because I know. Girl, no, and I can't call. My mom always keep talking. I'm sorry. My mom always keep talking about probate. Probate, and it calls you. It takes so many years, and at the end of the course, thank you. At the end of the course, you wind up with nothing. Basically, okay, thank you.
And I'm going to talk a lot about programs
Okay.
today, just so everyone knows exactly what the process looks like. Long as it's expensive. You can choose to later.
I'm jumping the gun. Okay.
No, I don't mind that.
We're gonna go ahead and get started. Looks like we have some that joined us online, so thank you for coming. So welcome to the Notary Connect networking group. So this is the quote I stand on when it comes to the networking group. It's not about what you know, but who you know. So our icebreaker this morning, so you have a card in front of you. You're going to write your answer. What is something you currently own that you would like to protect and pass down to your family? And while y'all are thinking, I'm gonna go first. So I am creating this empire. And I literally went the other night, I sat down, I was like, okay, what does this empire look like to me? And so as I wrote it out, I was like, oh, this stuff needs to be protected. business that I am creating, the empire that I'm building, I really need to protect that. So that's my piece of what I want to protect and what I want to pass down. I have 7 siblings right now, and 2 of them are like on my coattail. They're like, what you doing over there? And I can tell one of them, they comes to my house all the time. So I have in my mirror like affirmations. And so I went home a couple weekends ago, and in his room, he has affirmations on his mirror. So I know he's like looking at me to see what I'm doing. So I want to be able to protect what I have and pass it down to them. So just in case they want it, they have it. So Miss Bianca, would you like to come next?
Since you said that, I would say peace of mind for my children. So if something was to happen to me, it'll be one less thing that they have to worry about, or one less thing that they have to deal with. So more or less, it's not going to be a smooth transition, but I can make it as smooth and comfortable for them as possible.
Miss Flora?
I would want to pass down my phone to them.
Okay.
I don't want it to be complicated. I only have 2 kids. So that's one thing I want to pass down.
Here.
Mine is my family history and values. I want them and my grandkids, if I have grandkids someday, to know where I came from, to know about my parents, and to know where we come from and what we stand for.
All right, so this is me. I'm Rashana, Tulsa native, Army veteran, Notary Public, loan signing agent, apostille agent, and I call myself a resource. If I don't know it, I'll find somebody that does. And so the reason why I created the networking group is to create a community, connect with like-minded people. I want to grow myself and others, learn more about the industry, and then serve as a resource. I believe I was born to be a servant, so that's all I've done and know. Being in the military, and I started this business trying to help people vote. Like, that's just who I am. So next we will have Eric Cotton. He is a lawyer. He is also in my BNI group. That's how we met. I am super excited to bring him to you guys to teach us about estate planning. It is one of the things as notaries that we will actually see in this journey of notary work. And so I know I do a lot of power of attorneys going to different hospitals and stuff. And so he's going to teach us about that. So give me 1 second as I pull this up here.
Well, thank you so much, Brashana. I appreciate the chance to be here and
No problem.
speak with you guys. I've only known Brashana for a few months now, but honestly, she's amazing. And I know you guys know that. But getting to sit down with her and getting to know her better, her story really is quite amazing. It's really remarkable. Very impressive.
Thank you. My mouse has left me. Okay, there we go.
Sorry, of course, my PowerPoint is
Oh,
difficult.
no, you're good. You're good. It's just, I liked it so much. I was like, I don't want to ruin it.
You can ruin it away, no problem. Awesome, thank you. Perfect. Okay, so as Rashana said, my name is Eric Cotton. I'm an attorney, graduated from law school in Philadelphia at the University of Temple in 2005. I'm from Oklahoma though, grew up in Guthrie, born and raised. So came back here. My wife, Amber, was pregnant with our oldest, Caitlin, whenever we moved back. So we came back here to raise our family. Started off doing insurance defense work, car accidents, civil rights, things like that. And that's what I did for most of the beginning of my career. In 2012, I went off, opened my own firm. And that's really what I was doing, was plaintiffs' personal injury cases, civil rights cases, false arrest, excessive force, things like that. And I still do that. But a few years ago, I really started to see a need for estate planning, for good estate planning that worked when it was needed. And a couple of situations came up. My sister, she was married to a guy in Alabama. They had 2 kids. And 4 years ago, he passed away unexpectedly. Her estate is still in probate. He didn't have a will. He had no estate plan. But for whatever reason, for 4 years, she's been fighting to get the assets that are hers. And she still doesn't have them now. And as you can imagine, that creates a hardship trying to raise 2 kids without the assets that her husband would have wanted them to have. So I see that situation. And then a good friend of ours, his dad got remarried. The stepmom has a couple kids of her own. They've been married for years and years. He passed away, and it's been a constant fight. He had a trust set up, but it wasn't set up quite right. And as a result of that, his kids have been in court fighting with the stepmom and her kids over this estate. And I'll talk a lot more about that in detail as we go on. But those 2 situations really kind of clarified and showed me that there was a need for good estate planning. And that's why I started doing what I do now, trying to help people just make sure they've got everything set up properly, making sure when something does happen, it's as smooth and possible as it can be in a traumatic time for the family's life. And we don't want to add any stress to that by making this as difficult as it can be. So these are the people that I do this for. As you see, my wife, my daughter, Caitlin. There's my other 3, Elise, Owen, and Claire. And for me, that's kind of why I do this. And that's just really why I'm here. Today, we will talk about estate planning. We're really going to try and keep it basics. So dealing with what is estate planning, what's the easiest way to do it, how can we do it in a way that makes your family's life easy and keeps your family and loved ones out of court and out of conflict. So really the basics: wills, trust, advanced healthcare directive, and a power of attorney. And pretty much everybody knows what these are, but the power of attorney is a financial document that allows someone chosen by you to handle your financial affairs if you are incapacitated. There's 2 different types. One, it's called a springing power of attorney. It only takes effect if you are incapacitated, if you are no longer able to make your own decisions financially. The other kind, it's immediate, and that gives someone the power of attorney, the power to go into your bank accounts, to use your money, to pay your bills from the moment you sign it. That has risks, obviously, because they can do that right now. They could go wipe out your bank account. So it would have to be somebody you trust implicitly. But what we recommend is the springing one, because as long as you're able to, there's no need for somebody else to have that sort of access to your accounts and to be able to do that to you financially. So that's what we look at for the power of attorney. The advanced healthcare directive is exactly that. It's a healthcare directive. It directs the person that you choose to help them, guide them, and to show them what decisions you want if you're unable to make them. And that deals with things like what sort of care you want at the end of your life. Do you want to be resuscitated? Do you want to be given artificial food and water if you're unable to do it on your own? And so that helps. It takes a huge burden off your loved ones because you have made these decisions up front. They don't have to guess, what does mom or dad want? They don't have to fight with their siblings over what do we want. You've already told them what you want. Now they just have to show that to the hospital or show it to the doctors and go forward. It makes their life so much easier. And then wills and trusts. We'll definitely talk a lot more about trusts as we go on. These, as you know, just basically set forth how you want your estate to be distributed upon your passing. Who do you want to handle your estate, as the trustee or as the executor? And if you have minor children, who you would like to care for your minor children if something were to happen to you or to their parents. And we will definitely talk about this more. One thing to always keep in mind is that under Oklahoma law, if you only have a will, you have to go through the probate process. And you have to go to court, you have to have it signed off on by a judge, and all of that's a matter of public record. So we will get into all of that in much more detail as we keep going. And as you're thinking about this, one thing to keep in mind is kind of who are you planning for? And as you saw, for me, it's for my family, it's for my wife and my kids. And for you, it could be a spouse, it could be your children, it could be friends, could be planning for your business, kind of like Prashana was talking about, planning to make sure that your business survives and goes to someone you trust to continue to run it, that's able to continue to care for your clients, for your customers. So all of these things. Couple of things just to kind of think about personally. If something were to happen to you, if you were incapacitated, who in your life would step up for you and want to take on that role, would want to make those decisions for you? And these are just things that you would like to think about as you're kind of going along. Number one, is that who you would want to do it? And if so, that's very good. But the next question is, would they know where to find everything to care for your life while you're unable to? Do they know where all of your bank accounts are? Do they know where your life insurance policies are if you have? Do they know what bills need to be paid and who they need to be paid to? All of these little things that can make things very difficult for them, we want to make sure we've got everything lined up for them, everything's simple. So if something happens, there's a document that just shows everything they need to do, how to do it, and keep everything clear for them. And then as you talk about, if you have a business, you know, all of you guys are notaries and using this as a business, right? So for you, is there someone that would be able to maintain and to continue your business forward if you weren't able to do that? So that when you get better, your business is still there, still thriving, still ready for you to be able to keep it going. And of course, estate planning is also for you. As we've talked about a lot, with the financial power of attorney, with the advanced healthcare directive, when you plan ahead of time, you are protecting yourself too by making sure your wishes and the way you want to be cared for is taken into account and it is noted for your family so that they know too. Now, at this point, we're going to move forward. Got my button on here, sorry. And now we will spend a lot of time talking about probate. And probate is the plan that the state of Oklahoma has for everybody. So if you have no plan at all, this is the plan you have, and it's called probate. What happens in probate kind of basically is when somebody passes away, some member of their family has to go and file in court to be appointed as essentially their executor, as the person that's going to be responsible for their estate. So you go to court, the judge has to sign off on that. Once the judge signs off on that, you have to file notices to the creditors to give them a 2-month period of time to come in and file and say, yes, we have a claim against the estate. While that's going on, you start sorting out the assets, figuring out how much of what is there, and any of the potential heirs. And all of this, when it's filed, is a matter of public record. So all of your assets are online on OSCN for anybody to see. All of your heirs are online, including their ages and their addresses. And all of this is there for just anyone to find. Eventually, as you gather the assets, as you find out who all the creditors are, the court will grant you permission to sell any real estate and to basically liquidate the estate. And again, all of this has to go through the court. The judge has to sign off on it, and all of it's a matter of public record. Once you've done all of that, and there's a final accounting, the judge will sign off on that as well. They'll set forth how the estate's distributed, who gets how much your creditors get paid, how much whoever was handling the estate gets paid for the costs they have, and then how much the attorney gets paid. And still, all of this is a matter of public record, and then eventually everything's paid. Like we talked about with my sister, her case is going 4 years. It's still not done. She's paid her attorney thousands of dollars already. And again, still waiting. I have another friend, who's a neighbor of ours when we first moved back. He died about a year ago. He did not have a large estate. He had his home. He had
the clothing and the property inside his home. He had a couple of bank accounts, a little bit of cryptocurrency, maybe a couple $100,000, not a large estate. When he died, he was not married, no kids. His parents are the only two people that will inherit under the law. His estate is not settled yet. We're going on a year. His brother, stepbrother, or half-brother, I apologize, his half-brother from San Francisco is who is handling his estate. So his half-brother has flown back and forth a couple of times. They have over $10,000 in expenses. So far, the estate is incurred. It's coming out of what his parents are going to get. His attorney, the last time I checked, has asked for $3,500 for this 1 year of handling this probate. So that's $17,000 out of this man's estate that won't be going to his parents. Beyond that, I'm not even sure if he would want his parents to get or inherit the estate. I don't know if there's somebody else or a charity or something else that he would have wanted to happen with his property when he passed away. But he didn't have a plan. And so this is what happens. Now, under Oklahoma law, the simple question of who inherits if you don't have a plan is rather quite complicated. And you look at the first situation, which is, let's say somebody passes away, no plan, no estate, no will, no trust. If they have a surviving spouse and they have surviving children from the marriage, who gets the estate? Most people, I think, just assume the surviving spouse would probably get the estate. That's not the case. The surviving spouse only gets half of the estate. The other half goes to the children. So now the surviving spouse has half of what they had before, and the children have half. And that has the potential to create a ton of conflict. The second one, surviving spouse, and let's say there's a surviving child that was just of the deceased. That complicates it even more. Now they get half, the surviving spouse would get half of the jointly acquired property that they acquired during the marriage. And then the children would get the other half. The spouse would only also get, let's see, a third of the property that was acquired by the deceased, not through the joint venture. So if the husband or if the wife had acquired property before they got married, that wouldn't pass to their spouse. A portion of it would. The rest would be split up between the kids. And again, it just creates a lot of conflict and a lot of hardships for the spouse. Then even if there is a surviving spouse, no children, but there are surviving parents of the deceased or surviving brothers and sisters of the deceased, the surviving spouse would still not get everything unless it were all jointly acquired. So the surviving spouse would get 100% of jointly acquired, but they would have to split anything that the deceased acquired on their own. And again, just more conflict, more time in court, and more fighting. And then if there's no surviving spouse, it gets very complicated. It could go to the parents. If there are surviving parents, it could go to siblings. It could even go to grandparents or grandparents' children, just as the state tries to find the next closest relative to pass the estate down to. If they're unable to, the estate just takes it and they give it to the schools, is what they say. So if you don't have a plan, this is what the state of Oklahoma will do for you. They will try to find somebody, or they'll just keep it and use your estate for the benefit of the state. And the next issue is who handles your estate if it goes to probate. And again, this is dealt with under Oklahoma law. This is how it's broken down. There is a specific list, and it goes in this order. So the surviving spouse has the first opportunity to handle your estate. Otherwise, it goes to children, parents, siblings, grandchildren, next of kin, or even your creditors if there's no family, and they would get to handle your estate for you. but this is decided by the court. If there are, for example, multiple children that wish to handle your estate, they would all petition the court to do so if they can't agree. And then the judge would decide either one of them gets to, or she or she may let multiple people within the same bracket handle your estate together. Hopefully they can just agree. But again, it's just one more area where there is a possibility of conflict amongst your family because there was no planning in advance. And so that's what we really want to focus on, is just making sure there's a plan to avoid these sorts of things happening where you're leaving decisions to the courts and inviting conflict amongst your family. And now, if all of that's not bad enough, there is over $585 million in unclaimed property in Oklahoma. Yeah, and a lot of this is things like bank accounts or life insurance policies. And if someone passes away and their heirs don't know where to find these assets, they go to the state and they sit in the unclaimed property account for a certain period of time, and then eventually it reverts to the state as well. And so, again, you just want to avoid these things if you possibly can. So that's probate, and that's kind of how probate works. And we talked about if you have a will, that goes through probate too. The only difference is with a will, you at least get to say, this is where I want my assets to go. This is how I want it distributed. But probate can be avoided. And probate can be avoided with a revocable living trust. And the thing about a revocable living trust is if you set one up, the truth is you will not notice any difference in your day-to-day life as to how you will handle your assets. Your home would be owned by the trust, your vehicle would be owned by the trust, your bank accounts would be the name of the trust. But the trust's identifying number is your social security number. You're still the owner, you're the beneficiary. You are, while you're alive, you are the trust. You control it. If you're married, you and your spouse control the trust together, just like you do your bank accounts and your home. There's no difference. The difference is when you pass away, the trust does not go through probate because the trust is the owner, not you. So what happens is when you pass, if you have a trust, your heirs simply go to an attorney. They have the assets transferred however your trust determines. And there's a couple of different ways. They can go outright directly to your heirs in their name. So the assets would just be transferred in that way. You can also set up asset protection trusts for your children, where if you set it up properly, you can give your children the ability to protect their inheritance from creditors, from judgments, car accidents, medical bills, or even future divorce. And we never know what's going to happen with our kids in their relationships. But if you give that money to them outright and they're married, as you saw under Oklahoma probate law, most of the time a spouse is going to inherit some of your assets. If they get divorced and that money's commingled, that spouse would be entitled to a portion of the inheritance your kids got from you. But if you put it in this asset protection trust, because your kids would not be the owners of that asset, it would be protected from liability, creditors, and even spouses. So it's a huge thing that you can possibly give to your kids. There are some control issues. I mean, you can get very deep into this. The bottom line is you have to allow your kids to give up control of that trust, to name a trustee to handle it for them, where they still are able to use it, but they don't have the ultimate control over it. And that's how you get that asset protection. But again, if that's something that's of interest, we can talk about that in much more detail at another time. We don't want to go too far into this on the basics, but just so you know. Now, the important thing to remember is just setting up a trust isn't enough, though. You've got to make sure your trust is set up properly, that it's funded properly, and that your assets are in it properly so it works the way you want it to when it's needed. A lot of times, and as you guys know, you can go on LegalZoom, you can find do-it-yourself wills and do-it-yourself trusts. You can find those very cheaply, and they'll get done, and you'll have some papers that you could say, here, I have a trust. But if you don't make sure it's set up properly, those papers won't be worth what you paid for them. And kind of like we talked about with my friend a little bit, his father had a trust, but it wasn't done properly. He had been married to this lady for 30 years. He had a multi-million-dollar estate, and the bulk of that money was going to her. There were 3 accounts, little investment accounts, worth around $1 million that he wanted to go to his 3 kids. She was not content with that arrangement. She and her kids wanted all of it and didn't want that money to go to his kids. The problem was, number one, she was the trustee of the trust. After he passed, she was the one in charge of the trust. Number two, these 3 accounts were not properly titled and they were not properly identified in the trust. So it gave her just enough of an argument to make that, well, no, he didn't intend for those to go to you, even though it was very clear, and really everyone knew he did, but there was an argument to be made there. So the 3 kids had to sue the stepmom and the trust and the estate to try and get what they were entitled to, what their dad wanted them to have. They were in court for over a year. They went through depositions. They went through all the discovery process. They went through this nightmare. Eventually, because they were worried about what could happen at trial, they were worried about the possibility of a judge looking at it and saying, yeah, the trust wasn't set up exactly the way it should have. You guys get nothing. They ended up settling with the stepmom. She ended up getting more than she was supposed to. They ended up getting a lot less than their dad had intended. And between the 2 of them, after all of this, they ended up spending nearly $750,000 in attorney's fees of their dad's money, all because this trust was not properly set up. So all of this can be avoided, all the probate stuff can be avoided, but it's just vital that you make sure the assets are put into the trust properly. And then it's vital that you make sure if there's a change in your life, if there's a change in your family, or if there's a change in your assets, that you keep those properly in the trust too, so that there's no issues and no question that the trust controls and that everything is in it. As we've been going on, we've talked a little bit about some of these already. My spouse gets everything anyway. We've definitely talked about that. As you saw when we were walking through the probate, that is not necessarily true. And banking on your spouse getting everything is not a good estate plan. You only need to plan if you have money. And honestly, it's not just about money. It's also about making sure that there is someone set up to handle your financial and healthcare decisions if you're unable to. And it's about making sure that the assets you do have go where you need them to go, where you want them to go. And if you have kids, it's so much more important to have a plan with minor children involved, just to make sure you're not leaving those decisions to a judge who doesn't know you or your kids or your family. And then the last one is, and for some people, this may very well be real, is that I don't have the money to pay an attorney for this. But as we've talked about, it's going to be a lot more expensive if you let this go to probate, and it's going to come out of your estate, and your family is going to be the one that pays that difference. Typical trust plan is around $4,000 to $6,000, kind of depending on exactly what you do and some of the different options. But the 1-year probate for my friends was $7,500. My sister has spent about that much, probably more at this point. And then my friend who paid a lot more than that, the $750,000, you can spend a ton of money and time and heartache being in probate. And personally, I would suggest if you can avoid it, avoiding probate is a very good estate plan. The next steps, and this is just kind of my advice, would be simply meet with an attorney. Talk to someone about your family, your life, your assets, and your wishes. And make sure you've got the right people in place to make the decisions for you if it's ever needed. And just make sure you've got a plan to protect your estate and to protect your family, so you keep them out of court and out of conflict. And then finally, if you have children, make sure you have guardians named. And I would even suggest to you, if you have children, consider not just permanent guardians, but temporary guardians as well. Something of an emergency responder for your children, where if something happens to you, there's someone local that you know, if they get the call, will immediately come and take custody of your children with the proper legal documentation, so they can show the police, we have the authority to care for these children until the permanent guardians can get here. So many people have family all over the country that you wouldn't want your kids to spend one night in foster care or in DHS custody if we can avoid it. So I would recommend naming temporary emergency guardians, having them have the paperwork already there so that your kids are protected the entire time. And one of the most, probably the most traumatic time in the kid's life, they're not also being taken away to a stranger's house. So at this point, that is all I have. That's kind of the basics of all of this. If anyone has any questions, I'd be happy to answer some, as long as I've got time.
Yes.
And that's really kind of it.
Have questions? Thank you so much.
Thank you. I appreciate it very much.
I do have a
Yes.
question. You said for the trust, I understand that if you make adjustments or you gain access or a property, you need to add it to your trust. Is that difficult to add it to your trust?
It's not too bad. So for example, like if you're getting a bank account, you just put the name of the bank account in the name of the trust. So instead of you, it would be the trust's name. If you buy a car, the same thing, you just title in the name of the trust. And the same thing with a house or any property. If you're buying property, that's a really easy time to do it, because the title company would just title the name of the trust. If you need to transfer it, kind of like you did the quick claim deed for your kids, if you're transferring it, something you own currently, you just do a quick claim deed, change the name of the owner of the property to the name of the trust. That way, when you pass, all of your assets are owned by the trust, nothing changes, and then they're just dispersed from there. Now, with life insurance policies and things like that, you don't change the owner of the policy, you change the beneficiary. So when you pass, the beneficiary of the policy becomes the trust instead of a set individual.
Okay,
And so that's all you do.
okay.
Any other questions?
What do you have if on your deed, it has and something happens to one person?
Yeah, so if you have a deed with and a lot of times that's a spouse or something like that, then that property would stay with the spouse.
So it's like my mother and father, my father passed, so basically that's her property.
Yes, so that would be her property.
So if something happened to her,
Then you guys would be going to probate to deal with her estate. Yeah. And so for her, there's a couple of things you can do. You can do a pass on death, basically beneficiary, or she could set up a simple trust too, depending on her family situation, where that property would then go to the trust and be dispersed as she sees fit. Any other questions?
And you said the trust costs anywhere between $4,000 to $6,000 to do a trust.
Yes, yeah. And a couple of those, the difference is 4,000 is for a couple, and that's for a couple. So it's a little cheaper if it's only a single person. But if that's the trust, that's a will for both people in the marriage, to make sure that if there's anything that they fail to put in the trust, the will just says everything goes to the trust. That's also advanced healthcare directive and power of attorney for both people. The extra comes in a couple of possibilities. Number one is if you wanted to do the lifetime asset protection trust for your children, those are an extra $1,000 because those are extra trusts that would be created. And the other option is, and this is only for a married couple, but if you're married, there's some things you can do to kind of avoid that situation my friend's father found himself in. And that is, with a couple, you can set up the trust where when the first one passes away, half the estate stays in trust that is completely under the control of the surviving spouse, but the other half goes into another separate trust where the surviving spouse can use it, but they're not the owners of it. And it's an irrevocable trust that they have already decided where that goes when both pass away. And it's a great way in blended families to protect the children of either side, so that the children know, no matter what, this half of the estate, this portion of the estate is in trust for us when both pass away. And it really is a good tool to avoid conflict, to keep the step parent and the biological children from fighting these sorts of battles that my friend unfortunately went through. So for some people, that's a good thing and something they should definitely consider. And then for others, it's just not necessary. And that's why it's an option as well.
So say, okay, so I'm divorced and I have 3 children. And say that I was to get remarried, but I don't want nothing to change. I still want my trust, whatever it is, to stay in my children's name,
Yeah.
or their heirs or whatever. And are you able to do that? So if you and your spouse, if your new spouse get married, you obtain a home, a car, or whatever, but you still want whatever your asset was prior to your marriage to stay in your children's name.
Yeah, I got you. You can definitely do that. And so we could do that by simply keeping your trust separate from your spouse. And that way, everything you've got in the trust currently just would not be commingled. And that would just be your property separately. And when you pass away, by the terms of your trust, it would go to your children. And then what we could look at, if you were to get remarried and you and the spouse acquired property jointly, is setting up a trust for you guys jointly. And then determining how you two as a couple wanted that trust to be, depending on whether he had kids or, whatever the situation may be. We can absolutely plan for that to protect your kids so that they don't have any of those worries. And that's honestly a great thing to do. It saves so much fighting between your family later on.
Thank you, because this was very informative, enlightening, eye-opening, all the above. Like I said, yeah, I got things to do. So
And I'm here to help if you need it.
hey, don't be surprised if you get a call from me like, Eric, can we sit down and have a conversation?
Absolutely.
Ooh, Lord.
So just build on that just for a second. The initial meeting, free of charge for you guys. Thank you to Brashana for having me. Again, like we talked about, it could be anywhere from 90 minutes to 2 hours. And in that meeting, we go through everything. We will go through all of your finances, all of your assets, all of your bank accounts, your property, everything entirely. So we know we have everything listed. If something were to happen to you in one place where your kids can find it and take care of it, and make sure we don't lose anything to the state of Oklahoma. And then after we do that, after talking about all of your family and all of your assets, then we would spend the rest of the time on building your plan, on walking through will, trust, who do you want to make these decisions? Who do you want to be responsible for all of this stuff? And then making sure we get the right person, and then making sure we have backups too, so that nothing goes to the court. We keep it completely out of the court system if you choose a trust possible. And so that's what that meeting kind of looks like. So thank you, Bianca.
No, thank you.
Anything else?
That's it. I'm check with the people online real
Perfect.
quick.
Okay,
So is this your direct number or is this the office number?
that goes, it is my office number, but
Okay.
it goes directly to my cell phone. So
Okay.
you will hear only from me right now.
And you're in Guthrie?
I'm actually, during COVID, I started just working virtually out of my home.
Awesome.
Yep, so I can do virtual appointments, or I come to you guys, is what I've been doing mostly with my clients, is I go directly to them at their homes. And honestly, I've found in talking about these kinds of things, which most people don't love talking about, doing it in the comfort of their home has been easier. It seems to work well. Plus, all the documents that we need to talk about are already there. So wherever you guys are, I will happily come to you.
Does anyone have any questions online? If so, you can drop it in the chat or you can unmute. We can hear you. All
Thanks,
right,
Michelle.
well,
Thank you so much. I
I
really appreciate it.
appreciate
Oh,
you.
it's been a pleasure.
I'll give it up for Eric. Thank you so much for coming in. I really appreciate it. To wrap everything up, I just had some announcements. So Oklahoma Notary University will be doing some webinars starting in October. So October 10th through the 14th. We're doing a marketing webinar. That's every Monday. It's $97 per person. Anybody outside of the university, but if you're inside, it's definitely free. So marketing, that goes from SEO, social media, Google My Business page, all those things about marketing, getting clients for your business. We'll be teaching on that. Next is loan signing webinar. That's going to be October 6th through November 10th. That's every Thursday at 8 p.m. Anyone outside of the Notary University is $150 per person. Anybody inside is free to the students. But we will go over how to become a loan signing agent, common documents that you see in loan signings, how to set up your business, how to market your business. There's a 6-part series, and that's where I actually have a guest who's been doing the business for a minute. She's going to help me out. I'm super excited about that one. All right, so that is all I have. Anybody have any questions? Gwen, you have any questions? No?
You know what? I don't have a question. I'm gonna have to go back and listen to it again, but for the upcoming webinars, this is so funny. I do hope I will be able to access them because I will be on my cruise from October the 8th through the 16th.
Yes, ma'am.
So I will have to go back and access those, but everything else, no, not at this time. I don't have any questions.
Awesome. Well, thank you so much for coming. I greatly appreciate you.
Thank you for putting it on. I appreciate all you do. I really do.
All right. Well, I hope you all have a good one. I'm going to go ahead and end the live, and you have a good day, Ms. Gwen. Be safe out there.
Okay, you do the same, okay?
Okay. Bye-bye.
Bye-bye.